Usually when we talk about the law, there's this expectation of absolute precision.
Right.
Like, think of the legal system like an X-ray machine. You go into the hospital in absolute agony after a fall,
Yeah.
and the doctor runs an X-ray, pulls up the stark, jagged white lines of the image, and says, your bones are perfectly intact. You're fine. But you're obviously not fine.
You're in pain.
Exactly.
Yeah.
You have massive soft tissue damage.
Yeah.
But the problem isn't that the X-ray machine is broken. It's that the machine is literally hardwired to only see bones. It is completely blind to anything else.
Oh, that is a phenomenal way to look at it, because the law is designed to look for very specific, tangible elements. And if your injury doesn't match those, those specific elements, the legal machine simply cannot diagnose the crime.
Right. When you step into the world of statutory interpretation, specifically regarding bodily autonomy and consent, well, that blind spot becomes incredibly apparent. So, welcome to this deep dive.
Glad to be here.
Today, we're diving into a stack of legal sources centered around a deeply unsettling Supreme Judicial Court of Massachusetts case from 2007. It's called Suliveres v. Commonwealth. And the central question you need to understand today is this: can fraud, deceit, or impersonation legally substitute for physical force in the crime of rape?
And that is a question that, frankly, challenges the very foundation of how we understand criminal liability, consent, and the limits of judicial power.
It really does, because I'm talking directly to you, the listener, right now. You probably think you know exactly what constitutes consent. I mean, we all do, intuitively.
Yeah, sure.
But the legal machinery defining it and the specific rigid words a legislature chose centuries ago can lead to shocking outcomes that just completely defy our modern common sense.
Okay, let's unpack this. How are we going to navigate this? Can you map out the journey for us?
Absolutely. If we connect this to the bigger picture, we need to understand that the law doesn't operate on pure emotion or, modern morality. It operates on precedent and strict statutory text.
So, to understand this specific legal doctrine, we're going to first establish the black-letter statutory law of Massachusetts. Then we'll analyze the foundational 1959 precedent of Commonwealth v. Goldenberg.
Okay.
And finally, we will apply that established framework to the chilling modern facts of the Suliveres case, using a rigorous element-by-element analysis.
Let's set the stage then. What is the baseline here? Like, what is the core statutory concept of rape under Massachusetts law as it existed in these cases?
So the baseline is found in the general laws of Massachusetts, specifically GLC 265, Section 22B.
Okay, got it.
This statute defines the crime of rape and explicitly outlines two separate independent elements that must both be satisfied for a conviction.
Just two?
Just two. The prosecution must prove, first, that the act was compelled by force or by threat of bodily injury, and second, that it was against the will of the victim.
So two independent elements, force and against the will, meaning both of those boxes absolutely have to be checked by the prosecution.
Precisely. And I must emphasize a really critical legal distinction here, tying right back to your X-ray metaphor.
Good.
Under this statute, by force is the bone. It is a physical requirement. It is not legally synonymous with a mere lack of consent.
Wait, really? So lack of consent isn't enough?
No, it's not. You can have a situation where an act is theoretically against someone's true will, but if the physical element of force or threat of bodily injury is absent, the statutory definition of this specific crime is simply not met.
Wow. Okay, so forcing someone physically against their will seems straightforward enough for a jury to understand.
Right.
But what happens when the weapon used to overcome someone's will isn't physical strength, but a lie?
That's the big question.
Right. To really test this rule, we have to look at a foundational case from 1959. Let's analyze Commonwealth v. Goldenberg. First, what are the legally dispositive facts?
Well, the facts here are deeply disturbing. A woman went to the defendant, who is a physiotherapist, to procure an abortion. The defendant fraudulently told her that having intercourse with him was a necessary part of the medical procedure. He literally claimed it would help it some way.
Ugh, that is completely horrifying. An egregious abuse of a power dynamic.
It really is, and based entirely on that blatant medical lie, she submitted, and he proceeded to have intercourse with her.
So, looking at those disturbing facts, we have to figure out how the law handles that kind of manipulation and what was the core legal issue.
The precise legal question before the court was this: could the defendant's fraudulent representation of medical necessity both invalidate the victim's consent and supply the requisite force mandated by the statute?
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court applied the black-letter rule from GLC 265, Section 22B. The rule has two independent elements. First, the act must be against the will, meaning non-consensual. And second, the act must be compelled by force.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, against the will?
The court had to determine the sub-issue of whether the victim's physical agreement to the act negated the against the will element.
Even though she only agreed because of a lie.
Exactly. The sub-rule at the time basically dictated that if a person physically assents to the specific act taking place, the physical mechanism of their will hasn't been entirely overridden.
Wow.
Applying the facts, because she physically agreed to the intercourse, albeit based entirely on the fraudulent medical advice, the court found that it could not be proven beyond a reasonable doubt that the intercourse was strictly without her consent in the purely physical sense.
So she technically consented to the physical action.
Right. Therefore, the court concluded that the against the will element was highly problematic for the state to prove.
Understood. Now, what about the second element, by force?
Here, the court essentially had to ask a secondary question. Does lying to someone legally count as physically attacking them? Like, can a medical lie satisfy the statutory requirement of physical compulsion?
And what did they say?
The sub-rule established by the court here is incredibly strict. The statute demands actual physical force or the threat of bodily injury. Applying the facts to this element, the court noted that the woman's physical submission actually negatived the use of force.
Meaning there was no fight.
Exactly. There were no physical threats, no restraints, no violence. Therefore, the court concluded that the element of force was entirely absent. They established the lasting doctrine that fraud cannot be allowed to supply the place of the force which the statute makes mandatory.
And after analyzing all the elements, what was the court's final conclusion?
The court's ultimate holding was that because fraud cannot substitute for force, the mandatory elements of the statute were simply not met.
So he got away with it.
Essentially, yes. Obtaining sexual intercourse through fraud or deceit is not rape under Massachusetts statutory law. The conviction could not stand.
Man, here's where it gets really interesting. Because Goldenberg was decided in 1959. Society looked very different, and the medical field looked different.
Oh, absolutely.
Our entire cultural understanding of women's rights and bodily autonomy was, frankly, archaic. But let's fast forward nearly a half century to 2007. The world has changed. What happens when a new, deeply disturbing case challenges this exact decades-old precedent?
You get to see if the legal X-ray machine has evolved.
Exactly. Let's analyze Suliveres v. Commonwealth. First, what are the legally dispositive facts?
So the facts here read like an absolute nightmare. The complainant was asleep, alone, in a dark bedroom that she shared with her longtime boyfriend.
Okay.
The defendant, Alvin Suliveres, who was actually the boyfriend's brother, entered the room. In the dark, the complainant, who was not fully awake, assumed it was her boyfriend returning home.
Oh.
She even addressed him out loud by her boyfriend's name, and the defendant did not correct her. Instead, he got into bed and had intercourse with her.
That's just sickening.
She explicitly testified that she believed it was her boyfriend the entire time, and she stated she would have never consented if she had known it was the defendant. The defense claimed the encounter was fully consensual, while the Commonwealth argued her consent was procured fraudulently via impersonation.
That is the ultimate betrayal of trust in your own home. With those horrifying facts in front of the Supreme Judicial Court, what exactly were they being asked to decide, and what was the core legal issue?
The issue before the SJC was momentous. Should the court finally overrule the 48-year-old Goldenberg precedent and hold that misrepresentations, specifically impersonation and identity fraud, can legally substitute for the statutory requirement of force?
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court applied the exact same statute, GLC 265, Section 22B, which again has two mandatory elements. First, against the will, and second, by force.
But they added something, right?
Yes. To grapple with the Commonwealth's new arguments regarding identity theft and deception, the court introduced a critical sub-rule to evaluate the exact nature of the fraud involved. They distinguished between two distinct types of deception: fraud in the factum and fraud in the inducement.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, against the will?
The court had to address the Commonwealth's argument that the impersonation completely vitiated her consent.
Wait, I need to pause you right there for a second.
Yeah.
The prosecution argued the impersonation vitiated her consent. Vitiated, you mean completely erased, invalidated, or legally destroyed, right?
Exactly right. They argued her consent was legally erased because of the lie. So to evaluate this, the court used a legal framework derived from cases like United States v. Booker and Federico v. Brockton Credit Union. The sub-issue was whether the defendant's silence and impersonation was fraud in the factum, meaning she was deceived as to the fundamental physical nature of the act itself, or fraud in the inducement, meaning she was deceived only as to the collateral circumstances, the risks, or the identity of the person.
Okay, so the nature of the act versus the circumstances surrounding the act.
Correct. Applying this framework to the facts, the court observed that there was no claim the complainant didn't know she was engaging in a sex act.
Right, she knew what was happening physically.
Yes. She knew exactly what physical act was occurring. She was just horribly mistaken about who it was with. Therefore, the court concluded this was fraud in the inducement. Because she consciously intended to consent to the physical act of intercourse at that moment, technically a form of consent was present. This mirrored the physical submission we saw in Goldenberg.
Understood. Now, what about the second element, by force?
This is where the court looked at the Commonwealth's explicit plea to basically read the word force out of the statute in cases of severe identity fraud.
Did they buy it?
No. The sub-issue was whether the judicial branch even has the constitutional authority to expand the definition of force to include deceit. The sub-rule applied here relied on strict principles of statutory interpretation and legislative intent. The court noted that the legislature is presumed to be aware of court decisions.
They assume the lawmakers read the court rulings.
Yes. Applying this to the historical timeline, the court pointed out that in the 48 years since Goldenberg was decided in 1959, the rape statute had been amended 3 separate times by the state legislature.
Wow, 3 times.
Yeah. They changed penalties, they updated gender-neutral language. During that half-century, legal scholarship changed, societal attitudes completely shifted, and Goldenberg was even heavily criticized by a member of the court itself. Yet the legislature never once changed the by-force wording.
So they refused to touch it.
Exactly. Therefore, the court concluded it had to refuse to rewrite the clear intention expressed by the statute. Fraud, even identity fraud, still does not equal force.
And after analyzing all the elements, what was the court's final conclusion?
Synthesizing this, the court's ultimate holding was that fraudulently obtaining consent to sexual intercourse by impersonation does not constitute rape under the existing statute.
Incredible.
They formally declined to overrule Goldenberg. The court ruled that the defendant's motion for a required finding of not guilty, meaning the judge should have dismissed the case before it even went to the jury because the law simply didn't fit the facts, should have been granted by the lower court. And importantly, they noted that double jeopardy bars any subsequent retrial.
Just to clarify for everyone listening, double jeopardy means that once a defendant is acquitted or a court rules they cannot be found guilty on these charges, the state cannot try to prosecute them again for the exact same crime.
Right. They are legally untouchable for this specific event. It is a final binding outcome.
Okay, this is where I have to push back hard.
Yeah.
Because as a human being listening to the facts of Suliveres, this outcome is completely visceral and, frankly, infuriating.
I know.
You have a woman violated in her own bed. Why are the judges so terrified of expanding the definition of force on their own? If the law from 1959 is clearly outdated and failing victims, why didn't the court just say, you know what, deceit is a form of psychological force, we are updating the rule today? Why did they just fix it?
I completely understand the frustration, and that tension is exactly why this case is so heavily debated. But it comes down to a fundamental principle of our government, the separation of powers.
Okay.
It is simply not the judicial branch's job to write the laws. If judges decide to redefine words like force to mean fraud just because society's moral compass has shifted, they cross the line from interpreting the law to inventing it. They become unelected lawmakers.
They become a legislature of their own.
Exactly, and that is a very dangerous slippery slope. The legislature is the elected voice of the people. They had 48 years and 3 separate opportunities to amend the statute to include fraud or deceit.
And they didn't.
No. They actively chose to leave the word force intact. The court's hands were tied by the principle of judicial restraint. If the legislature doesn't act, the court cannot act for them, even if the result is morally repugnant.
So the court is drawing this massive line in the sand between two types of fraud, fraud in the factum and fraud in the inducement, because their hands are tied by the text.
Be precisely.
Okay, to really lock this in for you listening, we need to make this concrete. We're going to construct a visceral hypothetical to perfectly separate fraud in the factum from fraud in the inducement.
Let's do it.
Guided by the legal framework you just laid out, let's look at Hypo 1 fraud in the factum. Imagine you go to a medical specialist for a procedure on your throat. You are blindfolded, or maybe under local anesthesia.
Okay, setting the scene.
The doctor inserts his anatomy into your mouth, but because of the clinical setting and your obscured vision, you genuinely believe it's a cold, sterile medical instrument. That is fraud in the factum. You are completely deceived about the very fundamental nature of the physical act itself. You did not consent to a sex act. You consented to surgery.
Precisely. In that scenario, the law recognizes that your will was entirely bypassed regarding the physical reality of what was happening. There was zero consent to the act itself.
Right. Now, Hypo 2 fraud in the inducement. Imagine you are at a dimly lit bar. Someone smooth-talking convinces you, with fake documents and a rented entourage, that they are a famous billionaire pop star.
A classic con.
Right. And based entirely on that massive lie, you agree to go back to their hotel and have sex. In this scenario, you knew exactly what the physical act was. You knew you were consenting to intercourse. You were just lied to about the identity or the social and financial circumstances surrounding it.
What's fascinating here is how the court in Suliveres applied these exact concepts. The court decided that a woman in her own bed, in the dark, being impersonated by her boyfriend's brother, is legally closer to the fake billionaire at the bar, the inducement, than she is to the patient being violated by the fake medical instrument, the factum.
Wow. Even though she's in her own home.
Even though she's in her own home. Because the victim in Suliveres knew she was engaging in the physical act of intercourse, the court classified it as inducement. Mechanically, under the strict text of the law, the physical knowledge of the act was present.
Which brings us to the ultimate takeaway. For anyone listening, whether you are staring down a law school exam, trying to understand a confusing Supreme Court ruling in the news, or just wanting to understand how the legal system actually operates behind closed doors, how do we synthesize all of this?
Let's synthesize the doctrines from this deep dive into an actionable step-by-step diagnostic checklist. If you want to understand how courts think when navigating issues of consent, deceit, and statutory boundaries, here is your framework.
Okay, hit us with step 1.
Step 1 is statutory strictness. You must always start with the exact text of the statute. Are the elements separated?
Right, the bone and the soft tissue.
Exactly. If the statute requires force and against the will as independent bifurcated elements, you cannot blend them together just because it feels right. You must prove both independently.
What's step 2?
Step 2 is the force test. Analyze the facts strictly for actual physical compulsion or the threat of bodily injury.
Right.
If the state is trying to substitute deceit, impersonation, or a medical lie for physical force, flag it immediately.
Because of Goldenberg.
Because under the Goldenberg and Suliveres doctrine, fraud simply cannot supply force.
Step 3.
Step 3 is the fraud framework. If fraud is present, you must diagnose the exact type. Is it fraud in the factum, where the victim does not even know a sex act is occurring?
Like the fake medical instrument.
Right. Or is it fraud in the inducement, where the victim knows it's a sex act but is deceived about why or with whom? Under this precedent, fraud in the inducement does not invalidate the consent element enough to overcome a complete lack of physical force.
And the final step.
Step 4 is legislative intent versus judicial activism. Always check the timeline of the law. If the legislature has amended the statute over decades, but specifically left controversial language intact, appellate courts will likely practice judicial restraint.
They stay out of it.
They will refuse to rewrite the law from the bench, leaving the burden entirely on the elected lawmakers to update archaic definitions.
Thank you for that rigorous breakdown. It is incredibly helpful to see the exact structural machinery underneath these decisions.
My pleasure.
But I want to leave you, the listener, with a final thought to mull over. If a high court assumes that a legislature's failure to update a 48-year-old law means the legislature actively agrees with an outdated, narrow definition of consent, does our statutory law inherently lag decades behind society's moral understanding of bodily autonomy?
It's a heavy question.
Think back to our broken X-ray machine from the beginning of the deep dive. We expect the law to cleanly illuminate the truth of a violation. But if the machine is hardwired to only recognize broken bones, to only recognize physical force, How many other forms of coercion, psychological manipulation, and deeply harmful deceit are currently hiding, completely invisible, in the blind spots of our legal system?